Hello, welcome to the Immigration Department's Module 2 for new intern training. My name is Sheila, I'm the managing attorney. I'm going to share my screen. Okay, I'm hoping that's the correct screen. So this is Module 2. This is very brief, a little background on immigration law and policy to provide some context and foundation. I like to begin with this infographic because it shows, I think, how complicated and convoluted the process of legalizing one's immigration status can be, either for people who are already here or for people who are outside of the country and wanting to come in. For some lucky people, it might be straightforward, but for many people, it is a very long and complicated process. So I think this sort of captures, illustrates that point nicely. So we start with something very basic, and that is the three branches of U.S. government. At the top is the U.S. Constitution, and the U.S. Constitution is the supreme law of the land. It provides for a separation of powers. So we'll go through each of these three branches. Article 1 of the Constitution talks about the powers of the legislative branch. And that is, of course, Congress, which is comprised of the Senate and the House of Representatives. Immigration law practitioners are always waiting on Congress to act, to pass, whether it be comprehensive immigration reform, that is a sweeping law that tries at least to fix many of the problems that we're seeing in our broken immigration system, or we're waiting on Congress to pass more discrete laws like the DREAM Act that would help our dreamers, the current DACA recipients, or an Afghan Adjustment Act that would give a pathway to residency and citizenship to the many Afghan evacuees that our government brought here. So we are always waiting on Congress to pass immigration laws. Article 2 of the Constitution talks about the powers given to the executive branch. The executive branch carries out the laws. Usually when we think about the executive branch, we think about the president and the vice president, but there are many departments that the president appoints leaders for, and that is a big part of the federal government. And we're going to take a look at that in just a minute in one of the next slides. And the third branch is the judicial branch, and that is the branch that evaluates the laws. And usually we're talking about the Supreme Court, and then the lower courts, which are the appellate courts or circuit courts, and then the lowest courts are the district courts. So those are the three branches of government. Article 4 of the Constitution talks about the separation between federal government powers and state government powers. So federalism is the idea that a territory can be governed by two different levels of government. And so that is the federal or the national level, and then the state level. So here we have enumerated the types of things that the federal government has explicit authority to govern under the Constitution, and then we have the things that the states can govern. And then in the middle of the Venn diagram, we have things that fall under the powers of both federal and state governments. So what is the source of the federal government's power to regulate immigration? Well, the Constitution grants the federal government power to enact federal laws. Immigration law is absolutely a federal law, so it is national in scope. The states do not have rights to decide who is allowed within their borders. It's the national federal government that has that power. But where does it get that power? Well, Article 1 of the Constitution does grant Congress the power to establish a uniform rule of naturalization. That is the granting of citizenship. But immigration law and policy is a lot more than naturalization. And so if we ask, where does the federal government get its power to regulate immigration, to keep people out of the country? And it's not specifically explicitly mentioned in the Constitution, then we're going to start looking at Supreme Court cases. Because when there is an ambiguity in the Constitution or in laws, the courts step in to interpret. So we have one case here from 1889, and that is Ping versus US. And here the court held that the power to exclude non-citizens was inherent in its sovereignty, meaning inherent in its authority to govern itself. And then a little bit later in 1893, the Supreme Court also held that the federal government's power to regulate and enforce immigration was derived by the federal by its federal policy powers. So although immigration is not explicitly mentioned in the Constitution, the Supreme Court did step in and interpreted that immigration was an implied power based on the foreign policy powers given to the branches. These specific cases, these two cases, were cases where immigrants were arrested for violating the Chinese Exclusion Act, and the court upheld the act. So based on this act, these respondents were excluded from the country. They sued, and the Supreme Court stepped in and decided to uphold this law. And these are the two reasons that it gave for upholding this law, is that the idea of sovereignty and the US's authority to govern itself, and then also the fact that it is explicitly in the Constitution that the federal government has a power to regulate its foreign policy, and that immigration sort of fell within that. So what are the sources of current immigration law and policy? Well, the INA, the Immigration and Nationality Act, is our main statute. We always come back to it. It was passed in 1965, and it is the primary source of pertinent statutory law. Then we have the corresponding regulations that explain the statute further and provide guidance on how the statute is applied. This is how regulations work. They cannot go beyond the scope of the statute, but they can flesh it out. And if there is any vagueness in the statute or the regulations, the court steps in to interpret. So precedent decisions have the force of law and are binding on cases within the jurisdiction of that court or the appellate body making the decision. USCIS guidance provides the agency's policies and procedures supporting those laws and regulations. The USCIS policy manual is the primary source for agency guidance. The policy manual is helpful. It is written in a more plain English, and it is very accessible online. So we will be looking at it a little bit later in the training, and we do come back to it often during our weekly meetings whenever it is relevant to do so. Here's a chart about the branches of government again, just to show all the different departments that fall under the executive branch. And the two that we engage with the most are Justice Department and Homeland Security. So we'll take a look at those. Under the Department of Homeland Security, which we call DHS, we have ICE, which is Immigration and Customs Enforcement, USCIS, which is United States Citizenship and Immigration Services, and CBP, which is US Customs and Border Protection. The one we engage with the most out of those three is USCIS because they process the applications that we file on behalf of our clients. CBP is the agency that our clients come into contact with, usually the first officers that they come into contact with, either at the airports or at the ports of entry along the border. And ICE is the agency that is tasked with enforcing immigration law. So we sometimes have clients who may be in deportation proceedings and they have to check in with ICE. They have to report to ICE. So that's usually how we might come in contact with ICE. And then we have the Justice Department on the left. It's led by the U.S. Attorney General, and the U.S. Attorney General oversees the Executive Office for Immigration Review, which is EOIR, which you might see in the future in our work. And then we have the BIA, which is the appellate body, and then the Immigration Court, which is where we have clients who may be in proceedings or deportation. USCIS is a government agency that administers lawful immigration to the US. They have about 20,000 employees and contractors at more than 200 different offices. On March 1st, 2003, they assumed responsibility for immigration services and functions. And it was the Homeland Security Act of 2002 that dismantled the previous agency, the previous iteration of it, which was INS, the Immigration and Naturalization Service. And it created USCIS, ICE, and CBP. So these sub-agencies, these agencies are relatively new. They have not been around forever. So that's the end of our brief module 2, which gave an overview on some of the background for law and policy. I hope it was helpful. And the next module will be 3, and I will see you at that one. Thank you. Oops.